Before I start, it's an appropriate place for me to acknowledge a glaring omission in my introduction. I forgot, I neglected to also introduce a member of our team, Dave Rogers. Dave wasn't sitting here in the front row when I introduced everyone, and now I look up at the marijuana topic, and of course I'm reminded of Dave because Dave also, in addition to practicing law, is a representative up on Beacon Hill. He's been instrumental in the legislation, in the movement and the legislation passed that the Beacon Hill's working on to legalize recreational marijuana. Dave has been appointed to one of the members of the Joint Commission of the Senate and House, looking at the referendum and making recommendations and actually writing the bill. So that's why the Marijuana in the Workplace title made me think of Dave Rogers. So this topic has been presented on, I think, probably several times before this year. It keeps coming up. It remains to this day to be one of the biggest challenges employers in Massachusetts and across the country have in dealing with employees, what to do about marijuana usage and drug testing that results in a positive test for marijuana. Since I last presented, or we last presented on this last year, there's been big change in Massachusetts. There's been no change at the federal level, and there's been little change for employers. So the big change in Massachusetts, everyone should be aware that we now have legalized adult use recreational marijuana allowed in Massachusetts. No change at the federal level, meaning that marijuana is still classified as a Class 1 drug under the drug enforcement laws under the Controlled Substances Act at the federal level. So while marijuana has been either medical or adult use recreational has been legalized in many states, overriding that all, it's still treated as a Class 1 unlawful drug under the Controlled Substances Act. So that presents some very difficult questions without many answers as to how employers, what are the legal guidelines around dealing with marijuana use among your workforce. So now in Massachusetts we have legalized medical marijuana, and now we have legalized recreational marijuana. There are no, on the recreational adult use side, it's legalized now. There are no stores, retail stores, dispensaries that are open yet, and that's been pushed back, I think, till mid or end, I forget now, July or December of 2018. July 2018 is the date by which legal adult use stores are to open in Massachusetts. So I'll start with medical marijuana first. The marijuana statute specifically says on the medical side that nothing in the law requires any accommodation of any on-site medical use of marijuana in any place of employment or the smoking of medical marijuana in any public place. So you cannot, employers are not compelled to permit on-site medical use at any place of employment. So where this comes up for employers, and like I said, this is one of the most frequent issues I deal with my clients, is what do you do with an employee who has tested positive for marijuana, or prior to a testing comes in, says, I'm a medical patient, I've complied with Massachusetts law, I have my medical marijuana card under Massachusetts law, and I'm allowed to use marijuana. Under the federal law, particularly the ADA, so you look at the Massachusetts 151B handicap statute, which, similar to the ADA, requires employers to provide reasonable accommodations to employees with a serious medical condition. Under federal law, an employee is not entitled to use medical marijuana as a reasonable accommodation. But here we have state law which specifically allows for medical marijuana. And so the question employers face is there an obligation to make a reasonable accommodation to an employee who's got a medical condition and uses marijuana, whether during the day for an ongoing chronic condition or even at night on their own time outside the workplace, but will show up at work the next day or the next several days or weeks and likely test positive for marijuana, even though there may not be, even though in any that situation there's no marijuana use, there's no impairment while on the job. So at the federal level, all courts that have addressed this issue in states that have medical marijuana laws have concluded that there are no rights under the ADA. Marijuana is illegal under federal law. So under the federal ADA, marijuana use is not permissible to justify or require a reasonable accommodation, and employers are still free to terminate any employees who test positive for marijuana in violation of law or policy at the federal level. You know, at the state level, we do not at this point have any binding guidance from the courts as to what to do in Massachusetts. You know, there's now a case pending before the SJC, the Barbuto case. It's been widely reported in Massachusetts. Just quickly run through that. This is a situation where you have an applicant for employment in a non-safety sensitive position who was, I believe, provided a conditional offer of employment subject to drug testing. This particular prospective candidate suffers from Crohn's disease, has a medical marijuana card, is licensed and permissible to use medical marijuana to treat her Crohn's disease. She, subject to her offer of employment, she went through pre-employment screening, tested positive for marijuana, and the company pulled the offer and terminated her. She sued under 151B, claiming a violation of her rights as a handicapped person that argued that the employer was obligated to provide her with a reasonable accommodation and allow her to use medical marijuana. And she also brought a claim for a violation of the Privacy Act, challenging the drug test itself, as she was a person in a non-safety sensitive position, and this wasn't a case of reasonable suspicion. Obviously, you know, she hadn't even started work at the time, so there was no issue of her being impaired on the job. At the Superior Court level, her handicap discrimination claim was dismissed. It was appealed. The SJC took it on direct appellate review. The case was argued probably about 4 weeks ago, approximately, and we're waiting for a decision from the SJC as to how that issue is going to be handled strictly as an issue under Massachusetts law.
Gary,
Now,
she wasn't looking to use marijuana while she was working, right?
I don't believe so.
She was
think
not.
it was-
Absolutely
She was not.
Yeah.
She only used it at night.
Okay, so
And it was to stimulate her appetite.
okay, so Crohn's disease, I associated that with someone who would be using marijuana during the day, but in this case, Ms. Barbuto was looking to use marijuana only at night for her appetite. There are other medical conditions where there will be recommended treatments of using marijuana during the day, and there are some medical conditions where the recommended treatment will be such for anxiety, depression, things like that, and in this woman's case, use it only at night. So that's an important distinction, because if the use of marijuana is limited to off-duty hours at night, that person's not going to show up at work the next day impaired in any way. But that person will show up and will not be able to pass a drug test, as Ms. Barbuto was. So now we have recreational use in Massachusetts, or adult use. And so adults may possess and grow marijuana in their homes. Adults may possess marijuana outside their homes. Retail stores will be opening, at least as of right now, not before July 18th. The statute specifically states that employers are not required to permit or accommodate marijuana use by employees, and employers are not restricted to enact and enforce workplace policies restricting the consumption of marijuana by employees. We know the statistics show that marijuana use among adults has been increasing over the last several years. It's likely to assume that once the law is in effect now, legalizing recreational use. Once stores start opening, you can assume that marijuana use among adults may be on the rise. So how does that affect you as employers in terms of your drug policies, your drug-free workplace policies if you have one, and your testing protocols for employees, as well as what do you do when you've got someone who is either appears to be impaired, or you're doing a random drug test during the course of employment and that employee tests positive for marijuana and then produces a medical marijuana card. So Massachusetts law does not, while it decriminalizes marijuana, you're not required to permit use. It's illegal under federal law. Your drug-free workplace policies are still enforceable. But the question then, is it wise, and what should employers do in terms of drug testing policies? There's been a lot of talk and writings about if, for employees in a non-safety sensitive position, employers should consider eliminating marijuana as part of the testing protocol, because what you're going to face is you're going to face a substantial number, a measurable number of employees who are going to test positive for marijuana, which does not indicate impairment during the job, during the time of work. And are you going to be, as an employer, unduly restricting the available workforce, the available work pool, if you're going to eliminate from your hiring process or your ongoing employment workforce every single adult who tests positive for marijuana use without any indications of impairment on the job? So I've been talking to clients, most of whom have been receptive, of just in non-safety sensitive positions, just eliminating marijuana as part of the drug testing protocol. Your managers should still be vigilant and alert for impairment on the job, for someone who shows up at work or during the day, either appears to have an odor of marijuana, any signs that indicating marijuana use during the workforce, during the workday. You should take action on that. But you're opening up you're diving into a hornet's nest if you're going to continue to test non-safety sensitive employees for marijuana. So instead of a drug-free workplace policy, consider a no impairment policy. And you probably all know that the issue with the drug testing for marijuana specifically is that there's no correlation between a drug test for marijuana and current impairment, like there is with a breathalyzer or drug tests for narcotics or other illegal drugs. Situation I've faced with a number of clients when you have on the realm of medical marijuana, when you have, let's say, employees in a safety-sensitive position who could be using equipment, could be driving vehicles, either random drug testing or pre-employment test positive for marijuana in a safety-sensitive position. If you have relevant policies, appropriate policies as an employer, you're still free to terminate that employee as of right now in Massachusetts without any fear, pending what the SJC does in the Barbuda case. You have to make sure that any action you take is based on the marijuana use and not because of the underlying disability, and you don't want to open yourself up to a claim for disability discrimination. And one thing that I've been doing with clients is that we've had several situations where there's been random drug testing of employees in safety-sensitive positions. They fail, then they come in and say, oh, well, I have a medical marijuana card, and here it is. So then the employer's faced with the situation, someone's got a serious medical condition, got a medical marijuana card, tested positive. So one thing that some of my clients have done is they've reached out to the employee's doctor through the employee as if it was an ADA impairment situation, and we sent the doctor one of the ADA impairment checklist forms tailored for this, and basically asked the doctor to tell us, with the employee's consent, what's the condition and what has been your recommendation? Why did you certify this person for medical marijuana use, and what's your recommended prescription? Is it a condition that you've told the employee to use marijuana during the day to relieve an ongoing chronic disease, illness, or is it something that you've recommended the employee to use only at night to help sleep or to reduce anxiety at night? And in those instances where we've gotten information, signed authorization, and signed report back from the prescribing doctor that the use was needed and prescribed only for nighttime use. In most instances where we had good employees who failed the drug test, the companies has relied on that and said, and still been vigilant to watch that there's been no impairment during the day, but with the doctor's note that the required use and the reason that employee has a medical marijuana card is to use marijuana at night. In those instances, the clients have typically continued the person in their job. So the law is expanding on allowing legal use of marijuana. The employment laws so far have not been really keeping up. It presents a lot of questions, and it will continue to present questions until we get some definitive guidance from either the courts or or if the federal government makes any change to the Controlled Substances Act, which with current administration is probably not likely to happen. Okay, I see a question, Ellen?
Yeah, are you taking?
Go ahead.
Just
Sure.
have a comment, because immigration falls under federal law, that even though it's permissible, perhaps under certain circumstances statewide, that there could be issues on the immigration. So if you have employees who have visas or are here as immigrants on any type of status, I don't know if you've come up against that, but that's, I think, on notice, an alert to show that it could be permissible mass. And also the next thing, is there any mandatory reporting on behalf of the employer where it could sort of go into the hands?
I'm not aware of the reporting. I didn't get into it here, but there are federal statutes under, for instance, Department of Transportation regulations that if you have employees driving DOT-regulated trucks, which are over a certain tonnage, you're required as an employer to do drug testing, and you're required to take action if an employee fails a drug test, and that employee is subject to the DOT safe roads testing protocol. So the federal scheme is much different than the Massachusetts scheme. Right. But to answer your question about reporting, I'm not familiar with whether there is an affirmative obligation to report that to the DOT. I'll be here after. We'll pass it back to Tamsin.
I couldn't agree more with Gary's suggestion that you be very careful about testing for marijuana in non-safety sensitive positions, and particularly in light of Barbudo and in light of other case law under the Privacy Act. It may very well be that testing individuals in non-safety sensitive positions for drug use violates their privacy rights under the Massachusetts privacy law. Also, I think Gary's idea of getting a doctor involved if somebody tests positive for marijuana and you're concerned about their safety in the workplace is a fantastic idea, because you can rely on their doctor's documentation. And I would suggest that in addition to asking the time of the day that the marijuana is used, that you consider asking the doctor directly in what way this affects the employee's ability to do their job. And just like with an ADA questionnaire, you send them a job description so that the physician is aware of what the job requirements are and can opine about the individual patient's ability to do that job safely.